All right, top of the hour. Let's go ahead and get this on the road. I'd like to just take a moment for some housekeeping. First of all, thank you all for being here on time, and we'll look forward to catching up with you guys afterwards. First piece of housekeeping is please pay attention to your dashboard. On your dashboard, you'll find the handouts for the webinar. You'll find the questions and chat bar. We will be opening this up for questions towards the end of the presentation. So feel free to put your questions in there, and we'll get them in there and answered for you at the end of the presentation. Also, please keep an eye out for additional invitations for upcoming webinars. We have another one for Matt in 2 weeks. I'm sorry, 3 weeks, right, Matt? It's not going to be the 4th of July. So please be on the lookout for that. And a replay of this webinar will be emailed to everybody who registered and available on the Direct Source Wealth website. So without further delay, I'd like to introduce Matt Sorensen. Matt is an engaging speaker for starters. I've always enjoyed listening to him, and just in the two-way conversations that we had have been absolutely enlightening. He's the author of the best self-directed IRA handbook with over 10,000 copies sold. It's an Amazon bestseller in its category. He's a national speaker on estate planning, asset protection, entity selection, self-directed IRAs, and he is the entrepreneur's lawyer specializing in the real estate environment. So without further delay, Matt, it is up to you.
All right. Well, thanks so much for having me again. It's a pleasure to be back. I enjoyed the last webinar as well and all the questions that came through on self-directed IRAs. So today we'll be talking about some top asset protection and wealth preservation strategies. Really be going over what's widely used amongst real estate investors in general, looking at it from how to best protect your assets, also minimize taxes. And if you're doing those two things well, you're protecting your assets and you're minimizing your taxes, you're going to do a better job of transferring on wealth to your next generation, because those are really your greatest risks as you build wealth, is lawsuits and taxes. And so we want to figure out the best entities and structures to minimize that, and that's what we're really going to touch on as we go through the presentation today. Before we get into the content, of course, I'm a lawyer, so I got to make sure we touch on a disclaimer here. Keep in mind that any information discussed here is meant to be educational in nature. This webinar, our conversations do not constitute an attorney-client relationship here, so please seek out an attorney for your specific situation. Just a little bit more about me. I'm a partner at KQS Lawyers. We have an office here in Phoenix, which is where I'm located. We also have one in Southern California, one in Utah, and one in Idaho as well. Most of our lawyers help clients in the entity setup, setting up estate plans, LLCs, S corporations, helping clients with self-directed IRAs. I have a lot of real estate clients, from those raising money to those investing in deals to people buying their own rentals, whether it's a single family rental or a large commercial building or apartment complex. That's where we spend a lot of our time. I have a particular expertise with self-directed IRAs and speak across the country on that topic. My book's the most widely used book in the subject, Self-Directed IRA Handbook. I have my annual event, also the Self-Directed IRA Summit, which you can go to SDIRA Summit to learn more about. All right, well, enough about me. Let's get into some of the content here. I just want to give an overview of what we're going to talk about before we get into each of these different diagrams and structures that are helpful to build and protect your wealth. But here's what we're going to talk about: how to protect your personal assets from your business. So if I'm investing in things, real estate, whatever it may be, how to protect my personal assets. Another thing we'll talk about, how to protect your business assets from yourself. What if I personally have liability and someone's trying to go after the assets in my companies? How do we protect other assets such as cabins, second homes, other assets that aren't really business assets but are more personal assets? How do we protect the equity in our home? What shouldn't we do? What are some strategies that don't work that people may be promoting? And what are some of the easy things you can do as well? And we'll also talk about a couple newer things that are in asset protection. We'll try and mention those as well. So that's a big list here for, 30 to 45 minutes I have here to go over this. And we're going to come back and take questions. So if we don't touch on some of these enough that you have a specific question, put it into the chat window. We're going to come back and address questions. All right. Well, let's just start about what's the right entity to use. And if we take a step back, I want to just think about if you're already investing in real estate, in rental real estate, or you're already invested in a business or you have your own business, you're a sole proprietorship by default. So this is where you are. If you haven't set up a company, this is where you are already. So if this is me down here and I'm investing in real estate, either I bought something directly myself or I'm invested in someone else's deal, that income is going to flow through to me personally and go down onto my Schedule E on my personal tax return. Now, we're going to talk about what if there's an entity used up here. That changes a little bit. Also, if I have my own business, if I set up the lemonade stand, whatever it may be, I'm automatically an operating business. That income flows through on Schedule C. So rental income, passive income flows through over here on Schedule E. Ordinary income is going to flow through on Schedule C. Now, it's important to understand there's really two things going on here before we get into the entity structures. There's one is, what is the right entity from an asset protection standpoint? What's going to give me the most protection? And then second, what's the right entity to save on taxes that's going to be the most tax efficient? Now, that choice of entity you're going to use is different depending on what you're doing. So there's no one thing to do in all instances. It depends on what you're doing in your specific situation. Now, it's not rocket science. We're going to break it down so you know what entity to be using in the right situation. So let's first talk about the S corporation. An S corporation is the entity to use if you're a short-term real estate investor or you're an operating business owner. You're a dentist, if you're someone that does fix and flip real estate deals, you own a restaurant, you're a lawyer like me, you're going to want to use an S corporation. Now, there's two things happening here again I want to talk about. One, liability issues, and two, taxes. Now, the primary reason you want to use an S corporation is tax savings. Most people use an S corporation to save on self-employment tax. Now, you can see in this diagram here how this works. If I had the left side of the diagram here shows someone making $150,000 of income in their business with $60,000 of expenses. And let's say they didn't have an entity there, just a sole proprietorship. Or let's say they even used an LLC. Now, if that person makes 150 grand, they have 60,000 in expenses, they're going to have 90,000 of net income coming down to them. Now, when you have 90,000 of net income from a sole prop or an LLC, what happens is you're going to pay self-employment tax on that money of 15.3%, plus you're going to pay your regular income taxes based on your tax bracket. Now, the self-employment tax is the big tax saver here on using an S corp, which we're going to come to in a second. But if I don't have an S corp, what that means is I'm paying self-employment tax, 15.3% on 90,000 of net income. I'm paying self-employment tax of $13,500. That's before I pay income tax. This is just self-employment tax. This is Medicare, Social Security. When you're self-employed, you pay 15.3% of it on any ordinary income you have. Now, on the right-hand side here, we're using an S corporation instead. I still have 150,000 of income, but now I run it into my S corporation. I have 60,000 of expenses from the business. And now I still have 90,000 here to pay myself. But instead of just having 90,000 in net income drop out of the company to me, which I pay self-employment tax at 15.3% that you'll see on the sole prop LLC side, instead I'm going to take that same 90,000 here. I'm going to pay out a salary. Usually going to pay out at least a third of what you've made in salary. The IRS makes you pay a reasonable salary to yourself when you have your own S corporation. But then the rest of the money, I'm going to pay out in a dividend. In this instance, I could pay out $55,500 of dividend income. Now, the reason you're going to do that, the whole trick here is dividend income is exempt from the self-employment tax. So I'm not paying 15.3% on this $55,000. I do have to pay the 15.3% on the $30,000 salary I paid. So I have to pay self-employment tax on this $30K salary. That's the $4,500 here I have in the diagram. So now what happens is I have made the same 90 grand here net, but now I'm only paying self-employment tax of $4,500 as opposed to $13,500. This is a net tax savings of $8,500. Now that's $8,500 just for that year. If you think about using the right entity structure over a 10-year period, I mean, we're talking over $100,000 tax savings just by using the right entity. So for those doing short-term real estate, you're doing a lot of fix and flips, more than just a couple a year, or you're doing real estate development, you're doing commission, you're receiving commission income, you have an operating business, you're selling goods and services, whatever it may be, you definitely want to be using an S corporation. And this salary dividend split here, what we call it, where you can pay out dividend and profit income that's exempt from self-employment tax, that's the primary reason the S corporation is used. So the S corporation, remember, is used for a tax-saving strategy when you have operating income, an operational business. Now, if you have rental income, let's say you own a rental property or invested in a rental property, don't use an S corporation. Rental income is automatically exempt from self-employment tax entirely, so you don't need to run rental income through an S corporation. You don't need this for rental income, but you do need it for anything that's ordinary income. Ordinary income, again, is commission income, flip income, selling goods and services. It's not passive investment income like rental income. All right, so that's the S corporation. Again, remember, operating business, short-term income, it's a tax saver, saving on self-employment tax. Now, an S corporation, just so you know, we charge $800 in our office to set them up, plus state filing fees. You'll also have a tax return you'll need to file each year for the company to form 1120S tax return for the S corp. Now, also what's happening here when I'm using the S corporation, and this is the same protection of an LLC or a limited partnership, whenever I'm using an entity described here on the diagram, if let's say that I have a lawsuit in the company, if let's say the entity owns a piece of real estate, the tenant on the property sues the company, well, they're going to be forced to sue the business. They can't get down to the owners of the business because of something called the corporate veil. What the corporate veil does is it protects the owners of the business from the liability that occurs in the business. So if I have a company that owns real estate, something happens on that real estate, plaintiffs are forced to sue that company. They can't come down to me as an owner in that business. So this corporate veil here, that's what it's called, is what protects you as a business owner from the liability of your company. Now this corporate veil treatment is the same for corporations, LLCs, limited partnerships. They all have this same corporate veil protection. There's no difference there on this type of asset protection. There are some distinctions we'll talk about on some other liability risks, but the primary liability risk here of something happens in the business or a property that your company, your entity owns, they're forced to sue that entity. They can't come down to you personally. All right, now let's talk about the LLC. This is probably, the S Corp and the LLC, those are some of the two most widely used amongst people in real estate. The S Corp, again, being short-term operating income, commission income. The LLC, on the other hand, is more for your passive income. You have rental income, for example, or maybe you're invested in notes. What happens with the LLC is the LLC owns the property. If something happens on the property, again, the plaintiff's forced to sue the LLC. They can't come down to you as the individual owners. Now, there is no tax benefits to an LLC. You're not doing any salary dividend split like an S corporation. There's no tax perk for having an LLC. The benefit of the LLC is the asset protection. So we want to put assets in these, such as rentals. Now in this diagram here, we show this is a partnership, and this could be 10 people in here, this could be 2, it doesn't matter. But we have a number of partners invested into an LLC that in turn owns rental properties. Now from an administrative standpoint, what happens with this LLC is it needs to file a partnership tax return each year. It's Form 1065. And that partnership return will declare the income for the partnership and the expenses, and then it breaks down the profit or loss attributable to each partner, and they'll get a K-1 for their share of the profit or loss for tax purposes. And then you'll take that K-1 and you'll put it on your personal return to report the income. So LLCs are used typically for rental real estate or investment assets like notes. This could be single family, multifamily, doesn't really matter. LLC is going to be the entity of choice. But remember, since it's a rental income, there's no self-employment tax. You just pay it regular income tax rates on the rental income received. And the purpose of the LLC and benefit of it is solely asset protection. LLCs do not save on taxes. All right, now the next entity I just want to mention here is a limited partnership. And the limited partnership is generally used when you're trying to protect the assets of the company from the liability of the owners. All right, let me repeat that. Limited partnership is used to protect the assets of the company from the liability of the owners. Most people are trying to do the opposite. They're trying to protect their personal assets here from what's going on up here in an LLC. And they get that from an LLC because if something happens in the business, again, they sue the LLC, they can't come down to the owners. But what if I'm trying to protect the opposite? What if I have personal liability in my personal name and I don't want them to get up into my company to go after assets in my company? If you want that type of protection to protect them from going up and into the company to sell the assets, you would use a limited partnership. Or you could use something called a charging order entity LLC, or charging order protection entity is what we call it, a COPE. What happens in that type of entity is, let's say that I get in a car accident and I get a judgment against me personally, and a creditor is trying to come after me, and I have all of my assets up here in a limited partnership. I got investment accounts, I got my second home, or I got a cabin or whatever, or some raw land. That's all owned in a limited partnership. What's going to happen is the plaintiff cannot get into the limited partnership. They're stuck outside of it with what's called a charging order. This charging order prevents them from going up into the company to force the sale of the assets. If this was an LLC that I owned 100% and I had a judgment against me personally, in many states, a creditor is allowed to go into the LLC and force you to sell the entity, or excuse me, sell the assets if it's a single member LLC. Now there's some states like Wyoming, which is the state we typically use, where you can have an LLC that you can own 100% of, and you still get this charging order protection. And that you could use that Wyoming LLC to own your other LLCs in other states that own real estate. And that gives you charging order protection so they can't come up through the Wyoming LLC to the other entity to force the sale of assets. But in all instances, a limited partnership works. Now you'll notice the assets we have up here. These aren't just, these are up there intended to be there. The right assets for a limited partnership is investment accounts, second homes, cabins, raw land. One thing that is not up here that you should not put into a limited partnership is rental property. Do not use a limited partnership for your own rental properties. The reason for that is limited partnerships have loss limitations where you are limited on how much losses you can take for tax purposes. So we generally want to use LLCs to own rental real estate. If it's a second home or a farm or raw land, it's not rental real estate, so we're not worried about it. Or obviously investment accounts and things like that. Again, there's not rental real estate losses we're looking for here. So for a limited partnership, we actually don't use them a lot, but it's an entity out there quite regularly. So think of it for these situations, these types of assets up here, investment account, second home, raw land, or think of it for someone if you have a lot of personal liability and you want to put these types of assets in a limited partnership to protect them against a creditor. Now, one of the downsides of a limited partnership is you must have a general partner. The general partner should be another entity, typically another LLC. The general partner should not be you individually. The general partner takes liability for the limited partnership. So you don't want to personally be the general partner. Otherwise, you've just subjected yourself to the liability for the company. So the limited partnership should have a general partner, but that general partner should be another entity, such as an LLC. All right, we're going to come back to some of these just, I'm just hitting this overview here so you know the different entities and when to typically use them. So to summarize here, LLC for rentals, S corporation for operating business or short-term real estate flips, limited partnership for investment accounts, raw land, second homes. Now let's talk about, and this is, by the way, the diagram here I was just explaining on this charging order protection of you have a liability against you personally and they're trying to get into the business. This is where you get this charging order protection. Okay, now let's take another step back and look at this big picture. So we have some of the entities up here that we've talked about. I have my S corporation that does my short-term deals. That I have run my commission income through it. It's got my operating business, whatever it may be. I have my limited partnership that has my second home, or it has my investment accounts owned in it. I have my LLC here, which owns my rentals. I may have other investment accounts, or I've got my life insurance. I've also obviously got my residence, which we're going to talk about here in a second as well. Now, one thing that's in the middle here that is the central hub for all of this activity, this is the mechanism right here in the middle that's going to pass on your wealth to the next generation, is a revocable living trust. This revocable living trust is one of the most important things that any real estate owner, investor, someone who's looking to pass on wealth to the next generation should be using. Essentially, revocable living trust, what revocable means is you can change it at any time during your life. And your trust is really going to own your assets, as it shows in the diagram here. So it owns your S corp, it owns your LLC owns the property, it owns your limited partnership, the limited partnership owns the vacation home or the investment accounts. The trust owns your residence, it's on title to your home, not you personally. The trust is the beneficiary on your life insurance. It's also the beneficiary on your bank accounts or investment accounts. So when you die, everything goes to your trust. Now what your trust is going to do is, the first thing it does, it avoids probate. So when you die, we are all going to do that, whether you like it or not, we will die. You want to have a say in what happens to your estate. Everything's going to pass according to the terms you put into the trust. If you don't have an estate plan and you don't have a trust, or at least a will, the only person who's not going to have a say in your estate is you. So you're the one who best knows who should receive it under what conditions. So you need to get an estate plan done, and the trust is the primary document to do that. Now in the trust, a lot of things you can put into there, say, for example, if you're married, upon the first of us to die, the remainder of the assets go to the surviving spouse. Upon the death of the surviving spouse, then the assets get divided up amongst our kids. I'm just giving a general example here. But you can put restrictions on it. You can say, but only if the kids don't have a drug or alcohol addiction, only if they don't have a creditor that's chasing them down, because if they just inherit any of your money, then the creditor's just going to take it. You can put restrictions on it to say they get a third when they're 25, another third when they're 30, and the final third when they're 35. If you are concerned about passing on wealth too early to younger children, you definitely, if you have minor children, you do not want them to inherit all your money when they turn 18. So you want to put some provisions in there that maybe says from 18 to 25, you have enough income to pay for college or reasonable living expenses and support, but you don't just get an outright distribution of the estate. There's lots of different provisions you can put in here. If you have a business or you have real estate and rental properties or investment assets, maybe you have kids who are more interested in those that'll receive those specific assets over cash or life insurance proceeds. And maybe you designate them to receive that, and they'd have more value and feel in receiving that type of asset as opposed to just cash from a life insurance policy, which some kids frankly would rather just get that than get a portfolio of real estate investments or a business. So it's your estate. You can design it however you want, determine how to pass on wealth to the next generation. Now, in terms of passing it on without tax, there is something called estate tax. The nice thing is Congress did us a favor a few years ago, and estate tax exemption now is about $5.3 million. So for any estate below $5.3 million, you don't even need to stress about estate tax. Now that $5.3 million includes life insurance, it includes your residence, it includes everything you have that your estate's going to receive upon your death. If that's going to go over $5.3 million, you can do what's called a bypass or an AB trust that basically splits the estate up on the first spouse to die and allows you to take a $5.3 million deduction for the estate tax for the first spouse to die. Then you get another 5.3 on the second spouse to die. This just needs to be done upon the death of the first spouse to claim their exemption of 5.3 million. Then you get another 5.3 million, so you're up to like 10.6 million total of assets that can pass on without any estate tax. So the trust here, the purpose of this is to pass on your estate to the next generation. With some careful planning for those with larger estates, you can minimize the estate tax. If you have over a $10 million estate, there's additional strategies to use, but frankly, we don't have enough time for them. Some of those things would include irrevocable life insurance policies, charitable remainder trusts. There's a number of other strategies that could be implemented for those if you have over a $10 million estate. All right, now there's a number of questions that typically come up for people that we get in our office about when they're setting up a company. One of the big questions we get is people say, should I set up my company in Nevada? Let's say they live in California or they live somewhere else, but they've heard on AM radio they should set up their company in Nevada. That's not true. Do not go to Nevada to set up a company unless you live in Nevada or you're investing in Nevada or doing business in Nevada. Nevada is an oversold place to set up companies. Nevada is also broke. They've increased their fees on LLCs significantly. It's about $400 to $500 a year in fees just to the state to have a Nevada company. So we generally don't recommend Nevada. If you're looking for a state for asset protection, like a charging order protection benefit for LLCs or something like that, or if you're looking for a state that has very good privacy protection on their entities where your name's not listed with the state, we recommend Wyoming instead. Wyoming's only $100 to $150 a year, much easier, and has all the benefits that Nevada used to have. Nevada used to be the rage, but we don't recommend it for clients. It's been oversold and the fees there have gotten too expensive. Now, for most clients, our general rule of thumb is if you're buying real estate, the entity should be in the state where you're buying real estate. So if I live in California, but I'm buying property in Arizona, I'm going to do an Arizona LLC. That's just kind of a rule of thumb default. Should I use a C corporation? No, do not use a C corporation. You'll notice that's not one of the entities we went over here. If you're an operating business, we're going to recommend the S corporation here. In a C corporation, the difference between an S corporation and a C corporation is when you have profit here after your expenses, this $90,000 you have to pay yourself, the corporation has to pay corporate tax on it first. Then it distributes down the dividend income or the profit to you, and you pay income tax on it. So there's a double tax really with C Corp revenue, and because of that, you pay corporate tax, which goes up to almost 40%, plus you pay personal tax on it. C corporations are really only used for very large publicly traded companies or really old businesses that have never changed their business structure. It's very rare to see C corporations used for new businesses or entrepreneurs or particularly real estate investors. Definitely seek out a second opinion if anybody's told you to set up a C corporation. Another entity that's been popular over the last few years is called a series LLC. A series LLC is a very valuable entity if you have multiple real estate properties. So rather than an LLC, just a regular LLC, a series LLC allows you to have one entity, but it can own series that each owns a separate property. So for example, if I had 5 rental properties, and let's say they're in Texas. Texas is a state that has series LLCs. If I had 5 rental properties and they're all owned in one LLC, if something goes wrong on property number 1, that plaintiff could sue the LLC and they could go after the equity in all 5 properties, because anything in the LLC is still at risk. So if I have all my properties in one LLC, they could sue that LLC and all the assets in there are at risk. Now if I have a series LLC, what I can do is I can have a subseries own property number 1, the next subseries own property number 2, the next series own property number 3. And so it's only one entity, but it has separate, what are called series, which are their own entity in and of itself. You don't have to set those separate series up with the state. You just do one entity with the state. Then you can create with internal documents, it's just a 1.5 pager that we use, internal document, you adopt the series, and that series owns that property. If something goes wrong on property number 1 now, they can only sue the series for property number 1. They can't go after the other 4 properties. Those are all separate for liability purposes. So the series LLC is not available in all states, but it is in Utah, Nevada, Illinois, Texas, Oklahoma, Tennessee, Delaware. There's about 18 states now that have a series LLC, and there's 1 or 2 that comes on every year. So eventually this will be a very common entity structure. I think over time all states will have the series LLC option. Now if you're in a state, let's say Arizona where I'm at, and where I have rentals, there's no series LLC option. But if you have a lot of equity in your properties, and we kind of say over $200,000 of equity, and you own multiple rentals, you probably don't want those in the same LLC. We'd recommend separate LLCs for separate properties when you have $200,000 or more of equity. If you have, let's say you have 5 properties in one LLC, but there's only $10,000 of equity in every property. They're all mortgaged to the hilt. We're just going to say keep all those 5 properties in the same LLC. There's only $50,000 of equity total. If each property has $10,000 equity, there's only $50,000 total at risk. It's not worth the cost of a separate LLC to protect the properties from themselves. But if on the other hand, each property had $100,000 of equity and it's 5 properties, we're going to probably break those up between 2 separate LLCs or maybe even 3 just to make sure that the equity between those properties is protected and that we don't have all of our eggs in one basket, so to speak. But that would be a series LLC. Does a trust provide asset protection? No. There are some type of irrevocable trusts that can provide asset protection. We generally don't recommend those except in very, very complex asset protection plans. Trusts are typically used for estate planning purposes and for passing on wealth to the next generation. They're not an asset protection tool. A lot of people will mention land trust and they'll say, I'm going to do a land trust instead of an LLC. We do not recommend a land trust. Land trusts do not provide asset protection. If something happens and the trust is sued, they can go right down to you as the owner of the trust. Whereas in an LLC, for example, or a corporation, they're stuck at the company. So don't get fooled by land trusts. They don't have asset protection benefits. They can hide an asset by putting something in the trust's name as opposed to your name, but that's really the only benefit you get out of a land trust. Fees to set up an entity, our office charges $800 for an S corporation or an LLC or a limited partnership. The series LLC I mentioned is $1,500, and that includes up to 10 series. But on average, $800 is what we charge. And you shouldn't be paying more than a few $1,000s. I know sometimes lawyers are expensive, but you shouldn't be paying more than that for it. But also, on the other hand, you shouldn't be paying $99 online to do it because you're probably going to screw it up, or the company doing it doesn't know what they're doing, and they may set up the wrong entity or not file the right forms. So our office, again, $800. Try to be reasonable. That also includes an attorney consult. All right, what about protecting my home? Now, your home is one of the most difficult assets to protect. We don't like to put your home into an LLC. As you see here on the diagram, as a general rule, we want your home owned by your trust. This is for estate planning purposes because we want that asset to pass on to your family through your trust. For a lot of people, their home is one of their greatest assets. I don't want it in an LLC because I can lose the sale of home exemption if I put it into an LLC. Also, it's not like I have tenant in my home where I'm looking to protect, myself from what's going on in the property. What you're really trying to protect in your home is, if you get a personal liability against you, you don't want them to be able to sue you and get at your asset, the equity in your home. So a few things you can do to protect your home. Every state has something called a homestead exemption. Arizona has it. Where I'm at, every state has it. Here it's a $150,000 exemption that a creditor can't get that much equity. So if I have a property worth $500,000 and I got a loan on it for $400,000, the creditor could sell that property, but they're not going to get the first $150,000 of equity. So if they tried to force the sale of that, the bank would get paid off. I'd get up to $150,000. The creditor's going to get nothing. So you get some protection from a homestead exemption. Some states like Florida have an unlimited homestead exemption, but other states like Idaho may have like a $30 homestead, or excuse me, $30,000 homestead exemption. So it just depends on your state. You can look that up. Mark Kohler, my partner, has a book called The Tax and Legal Playbook that has the exemptions all in an index there. And that's I definitely recommend that book, The Tax and Legal Playbook, by my partner, Mark J. Kohler. You can find it on Amazon or on his site, markjkohler.com. But that's a great book that has tax and legal strategies for business owners and real estate investors. And it has charts on some of these state issues like the homestead exemption. The second thing you can do to protect your home is do a line of credit, or what's called equity stripping. In that situation, what you're doing is you're putting a loan on the property and you're pulling out the equity. So if I have a lot of equity in my home, I can get a home equity line of credit. Generally what the bank's going to do, let's say I have $500,000 of equity in my home and the bank says, we'll give you a $400,000 line of credit, home equity line of credit on the property. What they're going to do is they're going to put a lien on the property up to the maximum credit limit of $400,000. Now, I may not use that $400,000 line of credit. It's there if I need it. But from a creditor standpoint, if they're looking at your property and saying, oh, maybe this person's got some equity in their home, they're going to see a $400,000 lien on the property. So it makes your home a lot less valuable in the eyes of a creditor if it has a if it has a home equity line of credit on it. So now you could obviously pull on the line of credit or not, but in either event, the lien is on the property generally, as the bank's going to put the lien on up to the maximum credit amount. How are my retirement accounts protected? Retirement accounts are very well protected. That's one of the great things that you can pass on, or you can even have a lawsuit or go to bankruptcy and still keep. So most people that go to bankruptcy, as long as their retirement accounts are under $1 million, they'll be able to keep those retirement accounts and all their creditors get squeezed out. So plaintiffs, anybody suing you personally, it's going to be very difficult for them to get into your retirement accounts, whether these are IRAs or 401ks. There are some slight differences between IRAs and 401ks. The creditor protection for IRAs is based on state laws, whereas 401ks just has a federal protection that virtually makes it impossible for a creditor to collect. Most states have very strong creditor protection for IRAs. The one exception, of course, being California, which has still some good protection, but if you have an account over $1 million in IRA and you have a lawsuit against you personally in California, you could have some exposure above that $1 million. So, but everywhere else has pretty strong protections for IRAs. So retirement accounts are actually one of the best places to build wealth because it's the most difficult place for a creditor to try and collect on. This would be the example of, if you remember O.J. Simpson, for example, not guilty in criminal court, but guilty civilly. So the Nicole Brown Simpson family won the lawsuit against O.J. personally. He had like a $30 million judgment, but he was essentially living off of his NFL retirement account, and they could not touch that because of the creditor protection laws. So that's why he was still out on the golf course. That's why he moved to Florida, which has an unlimited homestead exemption, and bought a big house. And they had this civil judgment against him, but he was kind of the classic case of somebody who used these laws to really protect himself and prevent the creditor from collecting on him. As bad as that sounds, that's what he did, and he used the law to his advantage, unfortunately. Okay. Let me just look to the chat window here and see what questions we might have. Dave, I don't know if you want to jump in here too. Let me know if you've got questions.
Yeah, we got a couple of questions from Bob Malecki. Bob, thanks for joining us today. It's nice to see you again. On that, I use land trusts with my LLC as the beneficiary. Do you see an issue on this since the LLC provides the asset protection?
You can do that if what we wouldn't recommend is the land trust used instead of an LLC. So if the land trust is an extension of the LLC, so the LLC is essentially the beneficiary. So you own the LLC owns the land trust then owns the properties, I presume what you're describing there. That's okay. I presume you're using the land trust for some other reason, for privacy purposes, or maybe it's a subject to purchase issue or something that's a transactional reason, but we're not usually using land trusts, but I can see in that situation where it would work, and as long as you still have the LLC as the beneficiary, yes, it's a good option.
If I purchase a flip or a rental using my solo 401k, is there any asset protection? If not, what is the recommended way to use solo K funds to engage in a real estate investment?
A solo 401k does not have asset protection for its own investments. So if I'm buying real estate with my solo 401k, this was the last webinar too, just keep in mind if you missed that, but a solo 401k, while there is creditor protection for retirement accounts from your personal liabilities, let's say that I get a judgment against me, I default on a credit card company gets a judgment against Matt Sorensen, they're not going to be able to go into my 401k because that has creditor protection against my personal creditors. But if the 401k is making its own real estate investments, and let's say it's my solo 401k that buys a real estate investment and I get a lawsuit on that real estate investment that my 401k owns, they can get into my 401k and go after my 401k because it's an asset and an investment the 401k owns, and the 401k is responsible for its own liabilities. So yes, you would want to use an LLC. It's not necessary. You'll have most solo 401ks, at least the ones we set up, you'll have checkbook control right out of it. So you don't need the LLC for checkbook control like some people use for an IRA. They have to have that LLC to get checkbook control. But the LLC in the solo 401k realm is used for asset protection for that very situation, to protect the 401k in case there's something that goes wrong on the real estate investment.
Bob, for asking the first question, you get a 2-pack of Matt and Mark's books, Self-Directed IRA Handbook and the Tax and Legal Playbook. Thanks for kicking us off on the engagement portion of the webinar. Please email me.
I know Bob already has them, so just add to your collection, Bob.
There we go. Next question, Alexi. Can you talk about Delaware LLC? Is there a benefit to that state versus the state of property location?
Yeah, Delaware is kind of a popular state. I'd say the way it's kind of broken down is people in the Midwest and East Coast will use Delaware when they don't know what state to use or they're not sure. People on the West Coast now tend to use Wyoming. And I would say, kind of as lawyer practitioners in the real estate investment or business world, that's kind of how it breaks down. Now, Delaware is used more in like large corporations. There's corporate governance rules for large publicly traded companies, why people use Delaware. But it's also sometimes used, and we'll use it for clients who are like, well, I don't know where I'm going to invest, or maybe they're just going to invest in notes or things that, they have an online business. Their business isn't really attached to a state where like a real estate property is. So in those instances, we'll use Delaware. But if you're buying real estate, our default is always set up the LLC in the state where you're going to own the property. So if it's a Virginia property, we're going to do a Virginia LLC. I'm not going to set it up in Delaware typically, because if I do that, then I have to register it from Delaware into Virginia, and now you're paying fees to 2 states. But Delaware is a kind of a lower fee state, you know, the $100 to $150 range for a company there from a state fee standpoint, no state income tax. So it's gotten pretty popular even for non-publicly traded companies. But again, the primary rule of thumb is set up the entity in the state where the property is located.
Mark Young, why do you have XYZ Holdings, LL Limited Partnership, own 1% of XYZ Enterprises, S Corp?
Oh,
and thank you from Alexi.
Yeah, that's that 1% there is actually XYZ owns 1%. XYZ Enterprises, Inc., the S Corp, owns 1% of the limited partnership. The reason for that is the limited partnership, if you recall, must have a general partner. The general partner usually owns 1%. So we like an entity to be the general partner. So if our clients already use an S corporation and already have one, we'll typically use that company to be the general partner in a limited partnership. But this could be a separate LLC that's, you know, 100% owned by you or your trust. But every limited partnership must have a general partner. They typically just have 1%. So that's where that's coming from.
And Travis, if an LLC was set up and owns a rental property prior to the owner getting married, does it become joint property at the time of the marriage?
Not automatically, doesn't become joint property. If you keep it as separate property and treat it separate, you don't, you know, commingle the money and the income coming through it or putting money into it from joint accounts, it could still remain separate. So it just depends on how you treat it, really. And that's something, frankly, litigated about in divorce cases. One of the big issues is who owns this company. It was set up before you were married, but then how was it used once you were married? Did you treat it like it was both yours, or did you keep your money separate at all times? So that answer is it depends.
Okay. Thank you from Travis on that. Very good on that. Folks, if we don't have any more questions, we'll go ahead and wrap up for the day. Great questions so far in terms of what we're covering today and some excellent details. I just want to point out that we do have the upcoming webinar. You can see all of our event schedule at directsourcewealth.com/events, and keep an eye out for replays as well as the upcoming schedule. Matt, appreciate you being on here again yet today, and do look forward to connecting again. We got one last question, maybe last question, or we'll take a few more here. We got a couple of minutes. Do you recommend an LLC for first deeds of trust?
Not necessarily, because, again, the reason we're going to set up an entity is either tax savings, like an S Corp, or asset protection, such as an LLC. But a first deed of trust typically doesn't have much liability. You know, it's a paper asset. You're kind of playing lender there, playing the bank. So I don't see a necessity to have an LLC. It's not going to save me taxes by using an S Corp because it's just interest income. So I don't pay self-employment tax. So on first deeds of trust, you just own those personally. Now, if you do this on an ongoing basis, you're making a business of it, you have lots of them, you may want to use an LLC just to keep a demarcation of your business operations from your personal activities. But if you just own 1 or 2 first deeds of trust, you could just own them personally. Now, another caveat to that, though, is if you end up, you know, if this is a non-performing note, you end up foreclosing on it, you're going to want an LLC. But otherwise, if it's just a performing note, no need to have an entity. It's not a necessity. You could, but I don't see a big asset protection risk on a note, and having an entity is not going to save taxes.
Okay. That'll work. Matt, thank you again on that. Let's give it a couple of seconds here, see if any other last questions come through. But we'll go ahead and knock this one into the recordings and re-engage here in the near future.
All right. Thanks, guys. We'll see you for the next one. I think it's going to be tax strategies every real estate investor should know, so should be good.
Can you give a little preview about what is involved in those tax strategies?
Yeah, we'll talk about just some of the different tax rules for rental real estate, how losses get written off. There's 3 different categories of where you could be in terms of writing off rental real estate losses. One of the great benefits to investing in real estate is how to write off losses. A lot of people buy real estate for tax loss benefits. We'll go over that and how that can work. We'll talk about the active investors and the S Corp. We'll mention that again. And then we also will just talk about real estate investing in general, some of the strategies from 1031 exchanges to self-directed IRAs to general business expenses. How do you write off your mileage, meals and entertainment, just kind of those things that all, there's about 10 things that if you're doing right can add up to some big tax savings on your retirement account. And we'll keep it focused to real estate investors and entrepreneurs. So,
how does that apply in a passive earnings environment such as a K1 partnerships for our investors or 1099s from note income?
Well, it depends on whether activity and income you have. For K1s coming in, it depends on your income. You could still be considered an active investor possibly, so long as the K1 is coming from an LLC as opposed to a limited partnership. And you could look at writing off those losses as an active investor. But if you're totally passive and just getting a K1, you could be netting it against other rental real estate you may have, or other passive investments you have. You can always net passive real estate losses against other passive income. The real strategy is usually how can I write off my real estate losses against my personal income, my W-2 job, or my small business that I have that's, so how can I write off those real estate losses? Now for K1s coming from other, someone invests in one of your deals, those are more difficult to use to write off those losses against the personal income, like a W-2. But other rental properties they may have could be possibly used to write off against their personal income W-2. And there's 3 categories of it and how people will fall. We'll break down so people will know which category they fall into based on their different types of real estate investments.
Terrific. Matt, thanks again. We'll go ahead and call it a day. And thank you, everybody, for being here today and a number of really great questions. Thank you.